Government. Hey, we all know it's a major part of our life. But what happens if government, a governmental entity, the state, the county, federal governments, at fault for a claim? Can you sue them? Well, that takes us to this week's case. It involves a man. He ate some fish in a governmental cafeteria in Washington, D.C. Got very sick. Brought claim against the cafeteria and contended the cafeteria was at fault because they had not properly stored the fish and it allowed some bacteria to grow on it. Well, went forward on the case, and at court it was thrown out. Thrown out. Judge said, well, you can't sue government in this particular instance. Said you can't sue government because that was a discretionary act. Discretionary act, what is this all about? Well, this takes us to the rule that governs whether or not you can sue government. If government does something that's discretionary, that they either can do or can't do, and they have the ability to decide that, well, then they are given immunity for that. You can't sue them. But if they have to do something and they don't do it, then they are not given immunity and they become responsible. So in this instance, what the government argued was that it was discretionary with us as to the kind of standards we would use for keeping hygiene in our kitchens. And the manner in which we clean the kitchens, how we did it, that was all discretionary. And in this instance, if it wasn't done right, well, that was because we were trying to use whatever methods we used, and we got to choose the methods, and therefore we're not at fault. Well, the judge brought that argument, and he threw the case out. Fellow wasn't happy with this. He'd gotten really sick, so he took it up on appeal. It went up on appeal, and there the appellate court looked at it, and they said, no, wait a second. We disagree with the trial court because we find that the man who suffered the injury didn't say the government had the discretion to accept standards of hygiene. What he said was that they adopted standards and that they violated those standards. They didn't properly keep the place clean as they should have, as their standards said they should have. And therefore, while they had the ability to make a discretionary decision whether or not they wanted to have standards of hygiene, once they adopted those standards, then they had to maintain those standards. And what he's arguing is they didn't maintain those standards, and that's why he got sick. Therefore, the appellate court set it back down to the trial court to actually be tried. All right, so how does this really work with regard to what's discretionary, what's mandatory? Let's take another example. Let's say that you've got a major street in a town, and the county decides, well, that is a major thoroughfare, and therefore we're going to require that every side street that comes into that thoroughfare has to have a stop sign on it. All right, now we have Jim. Jim's driving along. Jim is going through this thoroughfare. He has not been there previously, when suddenly a guy pulls out from a side street, runs into him, and the guy says, I don't know why you didn't stop. This was an uncontrolled intersection. And Jim says, what do you mean? He said, well, there weren't any stop signs. And it turns out there was no stop sign installed there. So Jim sues the guy that hit him, and he also sues the county for not having a stop sign there. All right. If it is found that the county had decided to make that a thoroughfare, as we said they did, then they erred because some of their maintenance guys did not put up a stop sign as they were supposed to put up a stop sign, and they didn't engage in a mandatory service that was required. But it could have had a whole different ballgame. Let's say Jim's driving down this street, comes upon an uncontrolled intersection, again, not an area that he's familiar with, and bam, somebody pulls out and hits him. No stop sign. Same set of facts. But in that second case, it was an uncontrolled intersection, and the county had simply decided not to put stop signs there. And the intersection was an uncontrolled intersection without any stop signs on any of the corners, and the county just decided that's the way we're going to leave it. In that instance, that decision by the county, just to leave it the way it was without any stop signs, was a discretionary act. They could either have decided to do that or not do that. By virtue of the fact that they decided not to do it, made it a discretionary act, or they just make any decision on it, and therefore they could not be sued because they have immunity from discretion. In short, if government has the ability to decide whether or not to do something, they are immune from whatever judgment they make. If government has been told they must do something, then they do not have immunity, because what they are supposed to do is a mandatory act, and if they don't do it, they're at fault if something goes wrong. Okay, now this is kind of a little bit of a tough analysis under the law, and you can see from our first case here how courts sometimes can go different ways on that depending upon whether they view the act as discretionary or mandatory. Bringing you this here today, though, so you better understand the law, so you better understand how these decisions are made, so you can make the law work for you. I'm David Allen.